right now in place, the only law regarding putting employees on notice of a large layoff would be WARN, and that applies to employers of 75 or more. This would require a heck of a lot more notice for employees if you're going to do a layoff. The problem that causes for employers is if all of your employees know they're going to be out of a job in 60 or 90 days, they're going to probably not be giving you their best efforts, and they're going to be spending quite a bit of time trying to figure out how they can get a job somewhere else. So the more warning you give somebody that something's closing, the more likely you're not going to get their best efforts. You'd have to alert laid-off employees in a reasonable time about a layoff or positions opening up, and it would amend WARN to expand definition of mass layoff to include loss at more than one of employers' work sites and increase penalty for violations. So it's going to become far more onerous for employers. I will tell you, whenever you're doing a layoff, obviously the purpose is to save money and cut costs. If you mess this one up, it gets real expensive. So I would spend a lot of time working with a labor lawyer if you're going to do a large layoff to make sure you get it right and do all the proper provisions and notices to your employees. Other pending legislation, the Fair Pay Act. This would amend the Equal Pay Act provisions of the Fair Labor Standards Act to prohibit employers from discriminating against employees on the basis of sex, race, or national origin by paying lower wages than others if the jobs are equivalent. This, to me, is the scariest law out there other than the Employee Free Choice Act. Let me cut through the weeds and tell you what this really is saying. This has actually been a law the feminist movement has been trying to pass for decades now. What this law, in essence, would do, in the past, if you had two people that, let's say they were shipping clerks, one was a man, one was a female, you've got to pay them the same thing unless you can show there's a genuine objective reason to pay them differently. For instance, let's say one of them has more experience or does a better job. What this law would change is not only to say they no longer have to be in the same position, you are going to have a judge in their infinite wisdom to determine if jobs are equivalent. So let's say you had a male shipping clerk and a female who was in accounts receivable. Hypothetically speaking, a judge could come and say, those jobs are close enough, so you've got to pay folks the same thing unless you can show a real reason to pay them differently. This would make a mess of things because it would be so difficult for employers to determine if positions would be ultimately considered by a court to be functionally equivalent. It'd be a real challenge for employers, and this one scares the crud out of me for my employers' clients. Obviously, it'd be good for me, real bad for you. Again, while my family would appreciate the work, I hope it's not something that goes into place because it'll make a mess of things. Also, a lot of employers have in their handbook a provision that says you can't discuss your wages. That actually is already a violation of the law, but they're going to put that into the Fair Pay Act. You can't prevent people from talking about their wages, and so if Jane and Joan are complaining that they're not paid as much as their men, you can't say, hey, wages are a private matter and we only discuss it with you. You got to keep quiet. They'd also expand the Equal Pay Act to allow for recovery of compensatory and punitive damages. Right now, all they can really recover is what's called back pay, or what they would have been paid, as well as what are called liquidated damages or double damages. They want to expand that to allow for punitive damages, A, to punish the company, and B, to compensate the employees for their claimed troubles. What that in essence means is if she says, I've lost consortium with my husband and I can no longer sleep and I get headaches because me, an employer, didn't pay me as much as my counterpart, then damages could be far worse for you. The Paycheck Fairness Act, we talked about some of these things already regarding sharing salary information with coworkers, allowing prevailing plaintiff to recover compensatory and punitive damages, and a lot more class actions under the Equal Pay Act. Also, it would place the burden on the employer to prove the disparity in wages are not based on sex or job-related and consistent with business necessity. Think about that for a second. Normally, if you're accused of a crime or breaking the law in some regard, it is the plaintiff or the state that's got to prove you've done wrong. Now it's going to be incumbent upon the employer to prove a negative, meaning the employer's got to prove that they didn't do anything wrong, not that the other side just didn't prove their case. it's going to be a far bigger challenge for employers.